My greetings to all the listeners, speakers, and organizers of this conference. The Institute for Cultural Relations Policy targets to spread awareness of the worldwide issues. The focus of my presentation today will be the violation of the international law by Russian Federation that committed on the territory of Ukraine. The basic legal concept of state sovereignty in customary international law expressed inter alia in Article 2, Paragraph 1 of the United Nations Charter. It extends to the international waters and territorial sea of every state and to their airspace above its territory. Admittedly, one of the main elements of state sovereignty is constituted by the principle of sovereign equality, enshrined in the Article 1 of Charter of the United Nations, as well as in the Declaration on Principles of International Law concerning Friendly Relations and Cooperation among States, adopted by the General Assembly in 1970, and in Helsinki Final Act signed at the closing meeting of the third phase of the Conference on Security and Cooperation in Europe in 1975, which condemns the use of external force against the territorial integrity and political independence. It is worth to underline the provision of the Friendly Relations and Cooperation Declaration, which says that every state has the duty to refrain in international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the United Nations. The conflict that emerged in 2014 has its roots at the very outset of the post-Cold War period, because from the very beginning, Russia attempts to prevent Ukrainian independence, and when it's unavoidable, sought to limit it both in terms of territory and sovereignty. The victims of Russia's aggressions were Ukrainians' territorial integrity and the Euro-Atlantic rules-based order. Let's review the facts of the case. Russia planned military intervention in Crimea. Russia launched its very planned armed aggression against Ukraine on 20 February 2014, with the military operation of its armed forces of seizing a part of the Ukrainian territory, Crimean Peninsula. Reminder from history. On 19 February 1954, the Presidium of Supreme Soviet of Soviet Union issued a decree transferring the Crimean Peninsula from the Russian Soviet Federative Socialist Republic to the Ukrainian Soviet Socialist Republic, considering the integral character of the economy, territorial proximity, and the close economic and cultural ties between the Crimea and Ukraine. Experts believe that the operation to seize illegally the Crimean Peninsula was being prepared for a long time by Russia and simply expected for an opportunity to seize on overall vulnerability of the West. For decades, a lack of structural reforms, corruption, vested interests, and poor rule of law have weakened Ukrainian prospects for development and resilience against hybrid attacks. This day of sudden in Crimea became a center of pro-Russian demonstrations in the appearance of Russian volunteers, and on 16 March 2014 there happened an independence referendum and consequent Russian annexation of Crimea. According to Constitution of Ukraine, the issues of changing the territory of Ukraine can be solved exclusively by the all-encompassing territory of Ukrainian referendum. Therefore, it was decidedly invalid. The Council of Europe's Venice Commission has provided a declaration that the Crimean referendum was illegal under both Ukrainian and Crimean constitutions, as well as violated international election standards. First is that all the citizens of the nation will vote on that existential matter. Second, there were several voting irregularities. Therefore, when we raise the question on how state action can violate a state territorial integrity, we have to differentiate between two principal ways of violation, namely direct violation and indirect. The definition of direct violation of a state's territorial integrity should be derived from the General Assembly Resolution 1974, Article 3, which mentions invasion, occupation, annexation, bombardment, blockade of ports. Additionally, the use of foreign forces stationed with the territory of a state beyond what was upon between the troops sending and the troops receiving state.
Состояние и важнейший фактор стабильности в регионе. И эта стратегическая территория должна находиться под сильным, устойчивым суверенитетом, который по факту может быть только российским сегодня. Референдум был проведен открыто и честно. Собрание. И прошу рассмотреть конституционный закон о принятии в состав России двух новых субъектов Федерации – Республики Крым и города Севастополь.
In 2017, Ukraine launched a case in International Court of Justice against Russia on the subject of a violation of the International Convention for the Suppression of the Financing of the Terrorism and International Convention of the Elimination of all the forms of racial discrimination. In its judgment, the court made an important clarification that the state's financing of acts of terrorism lies outside the scope of International Convention for the Suppression of the Financing of Terrorism, although it subsequently states that such finding did not imply that state-sponsored terrorism was lawful under international law. 8 of November 2019, the court issued the major ruling in Ukrainian's case against the Russian Federation. The principal judicial organ of the United Nations extended from the 8 December 2020 to 8 of April 2021 the time limit for the filing the counter-memorial of the Russian Federation in the case. The agent of Russian Federation requested the court to extend by 12 months the time limit for the filing the counter-memorial, explaining that the restrictions due to the COVID-19 pandemic had led to ongoing difficulties and related delays in the preparation of the pleading. In further states that by a letter dated 22 of June 2020, the agent of Ukraine indicated that the Ukrainian government opposed the grant of any extension of the time limit for the filing of the counter-memorial, explaining that the coronavirus-related restrictions currently in place did not justify the extension requested, and that its extension would be severely prejudicial to Ukraine and would unduly delay the resolution of the case by the court. According to the annual report of the UN Secretary General about the situation of human rights in the Autonomous Republic of Crimea and the city of Sevastopol, Ukraine, the government of Russian Federation must uphold its obligations under international human rights in Crimea and to respect obligations that apply to it pursuant to international humanitarian law. Additionally, Russia must ensure the proper, unimpeded access of international human rights monitoring mission and human rights non-governmental organization to Crimea, pursuant to a General Assembly resolution, and to ensure unimpeded freedom of movement between Crimea and other parts of Ukraine. Russian infringement on the territorial integrity of Ukraine. On 24 of August 2014, regular units of the Russian army crossed the border in eastern Ukraine. The Kremlin's political decision to launch a direct military intervention was apparently a reaction on the threat of the effective collapse of the so-called Donetsk and Luhansk People's Republic. The main objective of the Russian offensive is to demonstrate that the government in Kiev cannot resolve the conflict through military means, and that it's necessary to start talks with the separatists and de facto with Russia on the political and geopolitical status of Ukraine. According to United Nations data, Russian aggression against Ukraine has left about 9,940 people killed and up to 23,455 wounded. Reminder from history, on 5th of December 1994 Budapest Memorandum on Security Assurances was originally signed by three nuclear powers, the Russian Federation, the United Kingdom, and the United States, who committed to respect the independence and sovereignty and the existing borders of Ukraine, and to refrain from the threat or use of force against the country. In the latter facts, Russia has broken virtually all the commitments it undertook in the document. It used military force to seize and then illegally annexed Ukrainian Crimean Peninsula in early 2014. Russian and Russian proxy forces has waged war for 6 years in the eastern Ukraine Donetsk region. As for today, Russia continues to illegally occupy Ukraine's Autonomic Republic of Crimea, the city of Sevastopol, certain areas of Donetsk and Luhansk, in total 7.2% of the territory of Ukraine. On 6th of June 2014, as an immediate measure to stabilize the situation in conflict area, was created a Normandy contact group, which constitutes the representatives of 4 countries, such as Germany, Russia, France, and Ukraine, aiming to resolve diplomatically the war in Donetsk, sometimes namely as Donbass, and therefore to establish peace. Russian Federation continuously contravened its commitments under the Minsk agreements. 5th of September 2014, the protocol of the result of consultations of the Trilateral Contract Group, or commonly known as the Minsk Protocol, with the aim to halt the war in the Donetsk region of Ukraine, was signed by the representatives of Russian Federation, the Donetsk People Republic, the Luhansk People Republic, and the Organization for Security and Cooperation in Europe. Since all the provisions were failed in implementation, on 12th of February 2015, the additional package of measures was negotiated at the summit in Minsk with the 4 countries' leaders.
From our part, we are ready to actually follow all the agreements, but this is the two-way street. Thank you, everybody.
Distinguished colleagues, ladies and gentlemen, overall, I can join the previous speakers. I can concur with the previous speakers. We have passed the final document, and the Minsk Accords will, from the 12th of February 2015, will have to be complied fully and unequivocally. The constitution needs to be amended that would allow for special status of the Donbass region. We also need to extend the law on the special status of Donbass, and that provision must be made permanent in line with the Minsk Accords that I use adjustments and amendments related to the Steinmeier formula, and other commitments need to be delivered on. Ukraine will begin establishing control over the territory on that part of the border on the next day following the election. That's what it says. The process is finalized after all the political procedures are finalized. Why do we need to undermine and rewrite the Minsk Accords?
Ukrainian side pursued to adopt clarifications or amendments to the agreement aiming to resolve the conflict fairly. Ukraine insists to withdrawal of armed forces and means of Russia from the territory of Ukraine, and only after that proclaim of the referendum in Donetsk and Luhansk People's Republics, while its opponents insist of the conduction of referendum at the first order, under the conditions that would cement Kremlin control over occupied eastern Ukraine, showing its position of allowing no concession. Are the current principles of the international law capable of facilitating the peaceful resolution of territorial conflicts? Only 7 out of 129 territorial disputes have been resolved by the International Court of Justice. Other legal efforts to resolve territorial disputes usually involve negotiations and third-party mediation. Back to Normandy 4, the next meeting was planned to happen in March 2020, but due to the coronavirus pandemic, it has been postponed. The latest meeting of the political advisors signifies the effort at moving forward to the resolution of the conflict and more negotiations on the issue. The war has been going for 6 years and already, and international attempts of peaceful negotiation did not bring measurable results. Numerous international organizations, including United Nations, are calling attention to the human rights abuses on the occupied territories, especially during pandemic. In December 2020, Russian occupation authorities continue their widespread repression against Crimean Tatars, ethnic Ukrainians, and all those opposed to the occupation. Definitely during the last few months the guns have been quieter, but we also comprehend that any ceasefire should lead to progress in the next steps in ending the conflict itself. However, other threats to safety persist and much more must be done to bring the conflict to a peaceful resolution. It is clear that the constructive change in Russian actions would require a proper compliance with the international law, its obligations and responsibilities. In that battle for new global leadership and survival in the 21st century, Ukraine is a very convenient testing ground for Russia in testing of hybrid war methods, technologies, informational influences, and military equipment. Having major support from the United Nations and OSCE mission, Ukraine seeks to eventually withdraw of troops from the east, disarmament of all illegal formations, and also reinstatement full control over the state border between Russia and Ukraine. International law cannot apply sporadically or set aside in pursuing convenient for aggressor solution. However, today's reality displays the statement that governments respect international law only when it meets their national interests. Likewise, the ability to exercise the control over a state's border and thereby assure its territorial integrity are essential attributes of sovereignty.